So we have this scenario with the juror. And because of this, Johnny had to respond. Johnny's not going to take this shit sitting down. Johnny's definitely not going to take this shit sitting down. So he's going to go ahead and he's going to write this, and he's got his great, fantastic lawyers. He's got Camille, and you know Camille is not going to put up with this bullshit. So they filed their own motion. Johnny's team filed their own motion to slap around Miss Heard. And here it is right here. So this is the actual motion. This is the filed on the 11th of June, right? I think 8 o'clock in the morning, 8:21 a.m. Okay. And this is plaintiff's memorandum in opposition of the post-trial motion. So this is Johnny's motion. This is Johnny's motion. Here. Oh, and I see Matrix says, love you, but suggestions, stream elements for donations so you get 100% money without having a second grift to YouTube. Sure, I'll set that up. I'll set that up after this. If I can, I'll try to set that up. I'll also try to get I know I've been kind of slacking on it. I got to get my PayPal link down there. So if you guys want to give it that way, but look, as long as if you guys are supporting me, you're supporting me. Right. And I appreciate it no matter how it comes in, I appreciate it. And I appreciate you guys, because without you guys, I wouldn't be able to do what I'm doing. I just literally wouldn't be able to do what I'm doing. So yeah, I give all the props to you guys, not to me, because I couldn't do it unless you guys are watching. And by the way, that's why it helps if you guys like the video. We're at 1,000 right now. If we get this to 500, right, that helps that get out there. And that really helps me. And honestly, the likes, the comments, the shares, that helps me more than even the super chats. So post-trial motion. This is Johnny here. He is filing the post-trial motion to rebut all of her bad arguments. Remember, I covered this. These are responses to Amber's terrible arguments. But of course, the court is not going to be going on YouTube and looking for our arguments against this. The court doesn't do that. Unfortunately, the court doesn't listen to me. They should, but they don't. They go and they have to listen to the opposing party and the law submitted by the opposing party. They're going to weigh that a lot stronger than arguments from outside. So you've got the arguments from Johnny's side saying the damages awarded by the jury are supported by the evidence and law. I agree with that, Johnny. The verdict on the complaint and counterclaim are consistent. I agree with that, Johnny. First Amendment does not bar recovery for defamation by implication, even when the statements at issue involve public figures or matters of concern. Nice. This was a horrible argument by Amber, and I'm glad they just make a strong statement against it. The juror's finding of defamation regarding the op-ed was consistent with and supported by law and facts, 100%. The jury's finding of actual malice is well supported in the record. Yep. Mr. Depp presented sufficient evidence to support a finding of defamation by innuendo. And there's supporting there. And lastly, number 8, the court should not conduct an investigation of Juror 15 because the defendant has waived such arguments and has failed to provide any evidence of unfair prejudice or a due process violation. Boom. They failed to say how even if this was the wrong person, they were harmed. Because here's the thing, guys. A harmless error is not an error and not a violation of due process. If there was indeed a harmless error, it is not a violation of due process. You have to show that your actual liberty has been impinged upon. A typo, a scrivener's error, is not an actual thing that is intruding on your liberty. This is the important thing. So let's get down there. Let's get down to business. Let's do this thing. We're going to go down to page 32. We're going to start in this section because this is what the people want. And I love I love giving the ladies what they want. I give the people what they want, right? And what the people want is to hear about Juror 15. Was Juror 15? And by the way, Pandal Eyes, we already covered the insurance stuff, bro. Go check out my stream from the other day. We covered it. Go check that out. New York Marine, we covered it. So that's out there. So once again, we're covering it all. We're doing it all, baby. 2 streams a day if I have to. Like today, I'm doing this one today right now on Amber Heard. We're going to have bikies later, Australian bikies later. We're going to be all over the place, not just doing Heard content. Miss Heard's desperate after the fact demand for an investigation of Juror 15. I love this. I love the way they started this. Desperate after the fact demand. Can't you just imagine Amber in her nagging voice? But Juror 15. I can totally imagine her doing that. For an investigation of Juror 15 based on the purported error in his birth date is misplaced. As a threshold issue, Ms. Heard waived her right to challenge the accuracy of the information lifted on the jury panel by failing to raise this objection contemporaneously. Boom. Done. Fucking house. This right here is so important. Let me explain this to you guys. So there's a reason why Nick and I and everybody else, when we're watching the trials, we're yelling object. If you ever have watched a trial with us or watched a trial with me on it, we're screaming object. Do you know why? Because you need to object to preserve the argument. If you fail to object to something, if you fail to raise your hand and say, I think that's a problem, you can't go back later and then say, oh, well, this was wrong. Your ruling on that objection was wrong because you haven't preserved it. You haven't said that was an objection contemporaneously. Now, there are certain things that are so bad they don't need to be objected to. Right? We'll get it, and I'm sure they're going to get into that. But this is a big issue. And I think for something like this, because they failed to preserve it, I think that's huge. I think that this is huge. This is why we say object, motherfuckers. Object. Just do it. My dog stepped on a bee. Objection. Objection. Fucking relevance. All right. And this is what the Supreme Court of Virginia says. It shall be sufficient that a party at the time of the ruling or order makes known to the court the action which he desires to take and his objections to the action and his grounds upon. So literally, at the time at which the problem comes up, you have to object. The main purpose of the contemporaneous objection is to alert the trial judge to possible errors so the judge may consider the issue intelligently and take any corrective actions necessary to avoid unnecessary appeals, reversals, and mistrials. Oh, what's up, Valiant? Good to see my brother in the chat. I lost. Can we go back and challenge jurors now? Yes, that's exactly the intent. Valiant, I'll you know what, Valiant? I have something I want to talk to you about. So I'm gonna send you a link for later. Like, if you want to come on and like, if your kids aren't killing you and you want to come on later, if Renegade Jr. is not building something cool with you and you want to come on later, I will send you the thing in the Twatters, the Twatterbird. And if you want to come on a little later, we can talk. Because I've got a couple things to ask you. That being said, let's continue. Okay, so the main purpose of the contemporaneous objection is to alert the trial judge as to possible errors so the judge may consider the issue intelligently and take any corrective actions necessary to avoid unnecessary appeals, reversals, and mistrials. So trying to dodge that right there. Further, the code outlines the procedure for objecting to irregularities in the juror list and to the alleged legal disabilities of jurors provides that unless an objection to such irregularity or disability is made pursuant to subsection A herein, and unless it appears the irregularity was intentional or that the irregularity or disability be as such probably caused injustice in a civil case to the party making the objection, then such irregularity or disability shall not be the cause for summoning a new panel of juror or for setting aside a juror. See, here's the standard. It had to have caused injustice. You cannot just have something here. These words are important. You know, this is the legal word. Real standards apply. This is Amber Heard's problem. Amber Heard has lived a life where she has never been held to a standard. She's gotten away with her crazy ass hoe shenanigans, her gaslighting, her lying, her getting away because she's blonde and has a pair of tits, getting away with a whole bunch of crazy shit. And now she's held to standards. Standards like you can complain about something, but you actually need to show it harmed you. That's a real world standard, not some fictional standard. Not your fifis were hurt. Not we're going to make stuff up. You actually have to prove damages. As further discussed below, Ms. Heard has shown no evidence of prejudice or injunctive, and therefore her belated argument regarding Juror 15 should be rejected by the court. So it talks about this case here, which says refusing to reverse cases where two convicted felons sat on the jury, no matter a matter which was not discovered until after trial because defendant made no showing of injustice. Holy shit. Can you imagine this case here? So let me just explain this to you, how big this is. So literally, there was a Virginia case with two convicted felons. Felons are not supposed to be serving on jurors. They're literal felons. There are felons on the jury panel. And the judge said, you know what? I don't think this is biased. I don't think this has caused an injustice. That's insane. Finding a defendant's objection to the qualification of the juror was untimely, where the defendant had knowledge of the fact that a brother of a sworn juror would be a material witness in the case, but did not make an objection until after the brother's testimony was not in accord with what he hoped and thought it would be. Even the relationship between the juror and the witness was sufficient reason for disqualifying the juror. Defendant, with full knowledge of this relationship, accepted him as a juror without objection. His objection to the qualification of the jury and his motion to discharge the jury came too late. This is another insane case. Imagine that. You've got you got a person giving testimony, right? So the lawyer looks at the juror and knows that the juror is the brother of a witness. And they said, you know what? I'm going to let you on. Because remember, the jury selection happens first, voir dire, however you want to say it. The selection of the jury happens first. And because of that, because that selection happens first, they've had ample opportunity. They've had ample opportunity to object to that jury, and they've chosen to allow them on. They could have moved at any point during the trial to strike the jury, to bring on the alternate. They, for some reason, didn't want to do that. And you know what I think it is? I think it was because they thought that jury was going to be good for them. I think they thought that jury was going to be great. And that jury ended up screwing them, as did all jurors, because it's funny. They pick jurors that believe the evidence and the truth. Isn't that funny? Isn't that funny? And by the way, shout out to KB, joining late from Michigan. What's up? To the soju to everybody out there in the chat. And let me get Patrick's here, who says, you're going to make me pay for it. Just kidding. I'll send you a bit all the time. I fell asleep in my chair and missed the start. I woke up and found out there's a locals chat on my birthday. What's the time of the topic? Well, if today's your birthday, happy birthday, Patrick. I did not know about that. I'm actually, so the link I put in my locals, by the way, this link, this is for this chat. So if you wanted to come on later, you can jump on here. And of course, we're reviewing this post-trial motion right now, but we'll be getting through that. So if you want to hop on and you're on my locals, you can hop on. I'll probably start allowing people on in like 30 minutes or so. So that's an option for you, Patrick, just like last time. All right, continuing on here. Contrary to Ms. Heard's contention or otherwise, the parties do not have a statutory obligation to verify the accuracy of information listed in the jury panel before trial, and any errors are not grounds for a mistrial. Any error in the information shown in such a copy of the jury panel shall not be grounds for a mistrial or assignable as an error on appeal. And the parties in this case shall be responsible for verifying the accuracy of this information. So literally, both Johnny's team and Amber's team are required to confirm information on the jury sheet. So the literal statutory law says that it is the duty of Amber and Johnny to confirm juror information. See, here's the thing. Amber's team was relying on like very loose and vague definitions in the jury instructions manual and very, very loose instructions in the code. They're here getting direct applicable language from the code. And by the way, thanks for everybody giving a shout out to Patrick, because Patrick is a great guy and he's been a great guy. So I do appreciate you guys showing him love. Kara says, oh, by the way, Kara asked, does locals allow you to play music without a copyright strike? Yep. I can play whatever I want. I can play whatever I want on locals. So if you have something you want me to see or play music of or whatever, I can play that on locals, which is why I sometimes do locals exclusive videos, because they're able to talk about that stuff or do that stuff. Disregarding this clear statutory language directly on point to Ms. Heard's issue with Juror 15, Ms. Heard shamelessly presents this argument to the court. Further, the clerk's office provided the pre-jury panel list to the parties on April 6, 2022, 5 days before the jury was impaneled, which gave Ms. Heard ample time to verify the accuracy of information contained therein. In a rare moment of candor, this is great. In a rare moment where Ms. Heard is not a lying bitch, Ms. Heard admits that she was aware of this purported discrepancy in Juror 15's birth year from the very start of the trial. Because, as Ms. Heard's team says, and I quote, Juror 15 was clearly born later than 1945. So they could see, so they admit that they could see that Juror 15 was not old. That Juror 15 was young. So Ms. Heard chose not to raise this alleged discrepancy with the court during the voir dire process or at any time during the 6-week trial and therefore waived it. Court case law says a motion for mistrial is untimely or properly refused when it is made after the jury has retired. Moreover, Ms. Heard's argument is one based on pure speculation. Ms. Heard cites the publicly available information that Juror 15 was actually born on 1970, but fails to attach such information to her motion or otherwise identify it for the court. Ms. Heard provides no support whatsoever for her conclusory assertion that her due process was somehow compromised. While Ms. Heard has a right to an impartial jury, she has failed to identify any way in which the inclusion and service of Juror 15, assuming arguendo there has been a mistake in this birth year, somehow robbed her of that opportunity. Unsurprisingly, Ms. Heard cites the no case law, so she has zero case law, to support her argument that the service of Juror 15, if he is not the same individual that the court assigned as Juror 15, somehow compromised her due process and warrants a drastic remedy of setting aside the verdict and ordering a new trial. Ms. Heard makes no showing of any prejudice, and accordingly, her speculative arguments fail. The quote is, neither the sole fact of irregularity nor the mere suspicion of injustice based upon irregularity is sufficient to warrant setting aside a jury. So literally, just suspecting that there's been an injustice is not enough to set aside a jury. And that's what Amber Heard wants. She wants people to just speculate and to throw out a jury decision for nothing, for mere conjecture, for no actual damage. You have to have, like Exa says, you have to have grounds. Like the Ilsa says, my dad was born in 1945 and he would have found your ass guilty too. 100% facts. By the way, Floral for 2 says, so do I satisfy the sexy enough quota? DM'd you. Floral, you definitely do satisfy the sexy enough quota. I will get you back. I told you I would be willing to come on a stream at some point. It's not going to be this week because I'm really busy this week, but it'll be the next couple weeks. Don't worry. We'll get you. You know, we'll find a good week for it. But thank you for that. Thank you for that. And like Valiant said, smash that like button and share the stream. I just did. Valiant, a fucking G, the fucking man. Appreciate that. Appreciate that. And the footnote here is pretty big. Someone says go back to footnotes. So the footnotes are good. So I'll read the footnotes. So on, I wanted to get the full quote though, the neither the soul, blah, blah, blah. That's a very fucking good quote. So let's do this here. On the afternoon of July 8th, let's zoom in actually. I'll make it larger for you people because I can't fucking read. Right? On the afternoon of July 8th, a full week after the deadline to file post-trial motions, Ms. Heard filed a supplemental memorandum in support of Section 7 of the defendant's post-trial motions based on additional discovered facts. As addressed in Mr. Depp's concurrently filed motion to strike, Ms. Heard's supplemental memorandum is untimely and should not be considered by the court. To the extent the court does consider this additional information, Mr. Depp maintains that his contention that Ms. Heard waived her argument with respect to Juror 15 has based her argument on pure speculation and provided no evidence that she was prejudiced in any way or that her due process was somehow violated. So no evidence, no facts. Next, see Beavers versus Commonwealth. Shout out to Beavers. Shout out to Beavers. The purpose of the selection procedure is to select a fair and impartial jury. The purpose of the voir dire examination is to ascertain whether any juror has any interest in the case or any bias or prejudice in relation to it, and the fact he stands indifferent to the cause. Boom. There you go. There you go. So the purpose is to ascertain whether any juror has any interest in the case or any prior or bias in it. So if there's no bias, you let him in. Oh, I love it. I love it. So my membership group is BLM, Base Legal Mindset, but I did realize that Ian is right here. It can also be Beavers Lives Matter. Beavers Lives Matter. And by the way, as Law Nerd Clips shouted, and by the way, shout out to Law Nerd Clips, put out fucking fantastic content, fire content. He says, congrats on ADTA at Legal Mindset. After your Rules of the Internet video, you definitely deserve the new subs. No, honestly, it needed to fucking happen. Somebody needed to explain the rules of the internet to these retarded lawyers. I'm just saying. They needed to understand. They needed to get educated. So your boy Legal Mindset's going to be the one to do it. But that's one of my favorite videos and favorite clips because I'm trying to clip stuff. So, okay, you've got the Beavers law there that's in support of this. So even assuming arguendo. So arguendo means for the sake of argument. So even assuming arguendo, Ms. Heard's latest thesis that a son served instead of his father. So that's the thesis, that the son went instead of his father. There would be no prejudice. As Juror 15 was qualified to serve as a juror in Fairfax County and was vetted during voir dire by the court and the party's counsel, just as all of the other jurors were. Such speculative arguments, unfounded in law and without factual basis, are improper at the post-trial motion stage. At this point, after a 6-week trial was held, the court should exercise its discretion and reject Ms. Heard's belated, speculative, and clearly pretextual arguments regarding Juror 15. And guys, that is the fucking mic drop. That right there is how Johnny Depp once again hands another L to Amber Heard. Amber Heard is going to lose this motion. This Juror 15 bullshit is going against Amber Heard. There's no fucking way. It's not based in fact. It's not based in law. It's not based in the record. It's not based in anything we've seen. And because of that, there's no fucking way the judge grants this. This is another Amber L. And I am always here for those Amber L's. And I will continue to cover all of those on my channel.